Colorado sues USDA, privacy battle over SNAP recipients' personal data. Food assistance crisis. Picture this. Your social security number and home address suddenly becoming fair game for the federal government. All because you're relying on a program meant to keep food on the table. That's the alarming reality at the center of a bold lawsuit launched by Colorado and a coalition of states. And it's raising serious questions about privacy, power, and who's really in control. If you're curious about how this could affect everyday people, or why tensions are boiling over, stick around. There's more to unpack than meets the eye. In a move that's shaking up the world of government assistance, Colorado teamed up with 19 other states and Washington, D.C. to take legal action against the U.S. Department of Agriculture, USDA, and its secretary, Brooke Rollins. The core issue? The USDA is demanding that states hand over highly personal details, think social security numbers, home addresses, and other sensitive data from folks who participate in the Supplemental Nutrition Assistance Program, or SNAP. This program, which many know as food stamps, is designed to help low-income individuals and families afford groceries, supporting nearly 615,000 people right here in Colorado alone. But the states are crying foul, arguing that this demand crosses a major line and is straight-up unconstitutional. To put this in perspective, SNAP isn't just a handout, it's a lifeline for millions across the country. For beginners, imagine it as a debit card system where eligible people get funds to buy food at stores, helping to combat hunger and promote better nutrition. In Colorado's case, the USDA stepped in back in May, instructing states to share this personal information about anyone who's applied for or is receiving SNAP benefits. And if states drag their feet or refuse, the USDA isn't mincing words. It's threatening to cut off crucial funding. For Colorado, that means potentially losing $96 million this year, funds that are earmarked for running the program smoothly, according to statements from Colorado Attorney General Phil Weiser. Weiser didn't hold back when describing the stakes. He pointed out that withholding this money could lead to widespread hunger and even endanger lives, especially for those who depend on SNAP to make ends meet. It could jeopardize people's health and very survival, he explained in no uncertain terms. This isn't just about paperwork, it's about real human impact. For instance, think about a family already struggling with job loss or medical bills. Losing access to food assistance could push them deeper into crisis, affecting kids' ability to focus in school or adults' capacity to work. But here's where it gets controversial. The states involved in the lawsuit aren't just upset about the funding threat. They're challenging the legality of the USDA's actions on multiple fronts. First off, they claim this demand violates the Federal Privacy Act, a law that ensures sensitive personal information stays confidential and isn't shared without good reason. In simple terms, if you've ever expected your social security number to be kept under wraps when dealing with government programs, this act is supposed to back that up. Weiser emphasized that in Colorado, protecting residents' data is a top priority, and residents have a reasonable expectation that their information won't be tossed around lightly. And this is the part most people miss. The USDA's request seems to clash with a long-standing tradition in the U.S., where states handle sensitive programs like elections, driver's licenses, and healthcare without federal overreach. Weiser highlighted that it's unclear why the USDA suddenly wants this data or what they plan to do with it. Could it be for improving program efficiency, or is there something else at play? Despite states reaching out for talks on safeguards to keep the data secure as required by law, the USDA hasn't responded, which Weiser called a red flag. That's not how things should work. It's not about blind trust. It's about following the rules, he noted. The lawsuit doesn't stop there. The states are also alleging that the USDA's actions break the Federal Administrative Procedure Act. This law basically requires government agencies to be transparent. They need to give advance notice of big changes, explain their reasoning, and allow the public to weigh in before making decisions. By skipping these steps, the USDA could be acting impulsively, leaving people in the dark. On top of that, there's a claim involving the spending clause of the Constitution, which gives Congress the power to control federal funds. The argument here is that the USDA doesn't have the authority to use funding as a club to force states into sharing information they're not legally entitled to. Weiser summed it up by saying, "This demand lacks any solid legal basis. It's an overstep, and we're calling it out." Ultimately, the states are asking the courts to step in and make sure SNAP funding keeps flowing as promised, without being used as leverage for unauthorized data grabs. Joining Colorado in this fight are states like Arizona, California, Connecticut, Delaware, Hawaii, Illinois, Kentucky, Maine, Maryland, Massachusetts, Michigan, Minnesota, New Jersey, New Mexico, New York, Oregon, Rhode Island, Washington, and Wisconsin. This broad alliance shows just how widespread the concerns are. Now, let's not shy away from the debate. Some might argue that the USDA needs this information to crack down on fraud or improve how SNAP operates, potentially making the program more efficient for everyone. But others see it as a dangerous erosion of privacy rights, especially in an era where data breaches are all too common. What do you think? Is this a necessary step for better oversight? Or does it cross a line that puts vulnerable people at even greater risk? We'd love to hear your thoughts in the comments. Do you agree with the state's pushback, or is there a case for the USDA's approach? Share your perspective, and let's keep the conversation going. Attorney General Bonta sues Trump administration over SNAP data privacy violation. Imagine the shock and outrage when you discover that the Trump administration is demanding states hand over sensitive personal data of millions of Supplemental Nutrition Assistance Program, SNAP, recipients. This move is just the latest in a series of attempts to collect unrelated, protected data to fuel mass deportation efforts. But here's where it gets controversial. The administration is suggesting that it could withhold funding if states refuse to comply, effectively forcing them to choose between protecting residents' privacy and providing critical nutrition assistance. Let's dive into the details. Oakland, California Attorney General Rob Bonta, leading a coalition of 21 attorneys general with New York Attorney General Letitia James, has announced a lawsuit challenging the U.S. Department of Agriculture's USDA demand for personal and sensitive information about millions of SNAP recipients. SNAP, a federally funded, state-administered program, provides billions of dollars in food assistance to tens of millions of low-income families across the country. When applicants provide their private information, they do so with the understanding, backed by long-standing state and federal laws, that their information will not be used for unrelated purposes. The USDA's threat to withhold administrative funding for the program if states fail to comply is a heavy-handed tactic that could have catastrophic consequences. California alone receives roughly $1 billion a year to administer the program, and any delay in that funding could be devastating for the state and its residents who rely on SNAP to put food on the table. In a lawsuit filed today in the U.S. District Court for the Northern District of California, Attorney General Bonta and the coalition argue that this demand violates multiple federal privacy laws and the U.S. Constitution. President Trump continues to weaponize private and sensitive personal information, not to root out fraud, but to create a culture of fear where people are unwilling to apply for essential services, said Attorney General Bonta. We're talking about kids not getting school lunch, fire victims not accessing emergency services, and other devastating and deadly consequences. That is Trump's vision for America, he continued. This unprecedented demand that states turn over SNAP data violates all kinds of state and federal privacy laws and further breaks the trust between the federal government and the people it serves. The president doesn't get to change the rules in the middle of the game, no matter how much he may want to. While he may be comfortable breaking promises to the American people, California is not. We will not comply with this illegal demand. We'll see the president in court. For 60 years, California and other states have administered SNAP, which serves as an essential safety net for millions of low-income Americans by providing credits that can be used to purchase groceries for themselves and their family members. Over these decades, the federal government and state agencies have worked together to build a robust process for ensuring that only eligible individuals receive benefits. In fact, the USDA itself has described SNAP as having one of the most rigorous quality control systems in the federal government. Those systems do not, and have never, required that states turn over sensitive, personally identifying information about millions of Americans without any meaningful restrictions on how that information is used or shared with other agencies. Yet in May 2025, the USDA made an unprecedented demand that states turn over massive amounts of personal information on all SNAP applicants and recipients, including social security numbers and home addresses, dating back 5 years. Even a year's worth of SNAP recipient data contains sensitive personal identifying information on tens of millions of individuals, including more than 5 million in California alone. The federal government's stated justifications for its unprecedented data demands to prevent fraud and abuse are directly contradicted by their own findings. Alarmingly, the USDA's demand appears to be part of a coordinated effort by the federal government to collect personal information on Americans from every possible source, to be used to advance this president's agenda. Public reports indicate that federal officials are amassing huge databases of personal information on Americans and using that data for undisclosed purposes, including immigration enforcement. Already, the Department of Homeland Security has obtained troves of personal information from both the Internal Revenue Service and the U.S. Health and Human Services Agency, including private medical information and other personal details on Medicaid recipients, which California has already challenged in court. The USDA's attempts to collect data from states about SNAP applicants and recipients appear to be the next step in this campaign. The USDA's actions are unprecedented, threaten the privacy of millions of families, and ignore long-standing restrictions on the use and redisclosure of SNAP data. Both federal and state law prohibit California from disclosing personally identifying SNAP data unless strictly necessary for the administration of the program, or if other limited circumstances exist. Those circumstances do not exist here. In today's lawsuit, Attorney General Bonta and the coalition argue that these demands violate multiple federal privacy laws, fail to meet the public comment requirements for this type of action, exceed USDA's statutory authority, and violate the spending clause. The coalition asks that the district court declare the Trump administration's demands unlawful and block the Trump administration from conditioning receipt of SNAP funding on states. Compliance with these demands. Attorneys General Bonta and James lead the Attorneys General of Arizona, Colorado, Connecticut, the District of Columbia, Delaware, Hawaii, Illinois, Maine, Maryland, Massachusetts, Michigan, Minnesota, Nevada, New Jersey, New Mexico, Oregon, Rhode Island, Washington, and Wisconsin, as well as the state of Kentucky, in filing the lawsuit. A copy of the lawsuit is available here. And this is the part most people miss: the broader implications of this data collection. If the federal government can demand and use this information for immigration enforcement, what other purposes might it be used for in the future? This is a slippery slope that could erode the trust between citizens and their government. What are your thoughts on this issue? Do you believe the federal government should have the right to demand such sensitive information, or do you think this is a clear overreach of power? Let us know in the comments.